All right, let me hit you with a wild legal story that changed the way we all think about responsibility. Picture this: 1928, a cafe in Scotland. A woman named May Donahue is out with a friend. Her friend buys her a ginger beer. Classic move. But here's where it gets weird. She sips, then discovers a decomposed snail in the bottle. A real slimy snail. Now, May gets sick, understandably, and wants to sue. But she didn't actually buy the drink, so she can't sue the cafe owner under contract law. So she goes after the manufacturer, Mr. Stevenson, instead. But here's the thing. Back then, the law said you could only sue if you had a direct contract. No contract, no case. But May's lawyers argue, hold up, shouldn't the manufacturer have a duty to make sure their drinks are, snail-free? This question made it all the way to the House of Lords, the UK's top court. And that's where Lord Atkin drops some legal wisdom that still echoes today. You must take reasonable care to avoid acts or omissions, which you can reasonably foresee would be likely to injure your neighbor. In other words, if your actions could harm someone nearby, like say putting a snail in their soda, you're responsible. This is called the neighbor principle. So, Donahue versus Stevenson became the foundation for modern negligence law. Suddenly, companies had to care about safety, even for people they'd never met. It's the reason you expect food and products to be safe today. So next time you crack open a drink, remember, one snail, one lawsuit, and boom, consumer protection was born. Wild how one cafe trip changed legal history, right? Follow for more quick legal facts.